Hi, my name is Max Frizzalone, and I'm a Maryland-based criminal defense attorney with my firm, Frizzwoods. In this video, I'm going to discuss whether or not police can search your vehicle without a warrant, how you might attack that, and how the state might try to justify it. So let's jump right into it. Can the police search your vehicle without a warrant? They can. However, the burden rests with the state to justify a warrantless search. Here in Maryland, if your car was searched without a warrant, your attorney needs to either file a motion or challenge it during a bench trial, at which time the burden would shift or move to the state to justify that search. I'm going to talk about some of the common justifications that I see. First and foremost, the most common justification for a search is a consent. So, if an officer wants to search your vehicle, often they'll pose it as a backwards question, like, you wouldn't mind if I searched your car, right? Because you have nothing in there. And then my client, thinking that by saying, yes, I mind, incriminates himself, says, no, I don't mind. That type of search is a valid basis to search a car. However, not every search is based on consent. So let's talk about searches without warrants, and those might be without consent or an arrest. Now we're in the realm of what we call the Carroll Doctrine, or the automobile search exception. The Carroll Doctrine stems from a United States Supreme Court in, I think, 1925, where some Canadian whiskey was being smuggled into Michigan. And in that case, the Supreme Court justified the warrantless entry into a motor vehicle as there was probable cause. And they said that's the standard probable cause. And that has been tested throughout the courts of this United States for many, many decades. I could give hour-long lectures about all the different types of probable cause that might justify a search or not. But for the most part, we commonly see things like a drug dog sniff or alert on a vehicle giving probable cause to search a vehicle. The third basis to search a car without a warrant is what we call plain view. And that one is common sense, or so it seems. If an officer sees something in plain view, meaning they don't have to manipulate anything, they just look inside your vehicle, sometimes with something like a flashlight, and they see, let's say, plain view drugs or a firearm on your passenger seat, that might give them a basis to search a car. Finally, the fourth exception is perhaps one of the most tricky. We call that the search incident to arrest. And to explain that to a non-lawyer, what I would say is searching a car after arresting somebody. And those are limited. One of the most common cases in the U.S. Supreme Court I see cited when attorneys attack searches incident to arrest is Arizona v. Gant. Essentially, what a search incident arrest boils down to is it can only be justified if the person is within arm's reach, and perhaps there could be a weapon in the vehicle, or more commonly what we see is that an officer is searching for evidence of the crime, but it must be the crime they're arresting the person for. So let's say, for example, you're being arrested for a minor offense like driving without a license. Can the officer search your trunk? Probably not. Probably going to be hard to justify. What are you looking for in his trunk? Evidence of him driving suspended, his license that he doesn't have? Not going to work. However, the person is being arrested for, let's say, controlled substances like drugs. You may be able to search their entire vehicle looking for other drugs, more evidence of possession of controlled dangerous substances. If you are a defendant in a case for someone you love and that case involves a motor vehicle search in the state of Maryland, we'd be happy to take a look at your case. And if you think we're a good fit, we'd be happy to represent you. Feel free to contact us for a confidential consultation. Good luck.